Let us continue our topic on domestic arbitration. There shall be three arbitrators for domestic arbitration. Qualifications and disqualifications. An arbitrator must be of legal age, be in full employment of his civil right, and know how to read and write. The foregoing qualifications are prescribed in the arbitration law and in the IRR. However, they are not similarly required for international commercial arbitration except that an arbitrator in ICA may be challenged if he does not possess the qualifications agreed to by parties. No person shall serve as an arbitrator in any proceedings if he is related by blood or marriage within the sixth degree to either party to the controversy. Next, he has or has had financially, fiduciary, or other interests in the controversy or cause to be decided in the result of the proceeding. Third, he has personal bias which might prejudice the right of any party to a fair and impartial award, or he has been selected to act as champion or to advocate a party's cause. Procedures for the appointment of arbitrators. The parties in a domestic arbitration are free to agree on the procedure for the appointment of arbitrators, except that, in order to prevent undue advantage, an agreement or clause giving a party the power to choose more arbitrators than the other is void. The parties may agree to authorize the arbitrators already appointed. Take note of the word already appointed. So the arbitrator who will be given the authority is already appointed to select and appoint additional arbitrators who shall sit with the original arbitrators. If there is no agreement for the appointment, the following are the default rules. So we have one, in an arbitration with three arbitrators, each party shall appoint one, and the two arbitrators appointed shall appoint the third arbitrator within 30 days from the receipt of the request, failing of which the appointment shall be made by the appointing authority. Second, default of appointment. The appointing authority in ad hoc domestic arbitration, in the absence of an agreement of the parties in the national president or integrated bar of the Philippines or his authorized representative in an institutional arbitration, there is no need for an appointing authority for purposes of appointing because the parties have already designated the institutional alternative dispute resolution provider, under whose rules the arbitrator or arbitrators to be selected. So the appointing authority make the appointment or give the appointing party who objects to a default appointment time, okay, to make the appointment, but not more than 30 days. Third, the request for appointment with proof of delivery to the adverse party shall be filed with the appointing authority within 7 days from the receipt of the request. The adverse party may file his objections to request or ask for an extension for not exceeding 30 days to appoint arbitrator. Number 4. In accepting the appointment, shall submit an acceptance letter which shall include statements that he agrees to comply with the applicable law and rules of arbitration. He accepts the applicable arbitrator's fees and he agrees to devote much time and attention to the arbitration as required. Number 5, arbitrators shall take an oath to faithfully and fully hear and examine the matters in controversy and to make a just award according to the best of their ability and understanding. An arbitrator may be challenged only if circumstances exist that give rise to a justifiable doubt as to his impartiality or independence. Second, he does not possess the qualifications provided for under the law or agreed by the parties as discussed a while ago. He is disqualified to act as an arbitrator. He refuses to respond to questions by a party regarding the nature and extent of his professional dealings with a party or counsel. The party appointing an arbitrator may challenge that arbitrator for reasons which the party became aware of after the appointment was made. Otherwise, he is already prevented from challenging the appointment he made. If an arbitrator appointed discoveries the existence of any circumstance that would create presumption of bias or would render with partial arbitrator, he shall immediately disclose such information to the parties. The procedure for the challenge against an arbitrator in a domestic arbitration is similar to that provided for in international commercial arbitration. The general rule is that the procedure that is agreed upon by the parties for challenging an arbitrator shall be applied. In default, the following procedures shall govern. 1. The challenging party shall send a written statement of the reasons for challenge to the arbitral tribunal within 15 days after becoming aware of the constitution of the arbitral tribunal or after becoming aware of the circumstances surrounding the ground for challenge. A request for inhibition shall be deemed a challenge. Number 2, within 15 days from receipt, okay, particularly the challenge arbitrator may either accept or reject the challenge. If he accepts, okay, he shall voluntarily withdraw as arbitrator. Number 3, if he rejects the challenge, he shall communicate within the same period of 15 days his rejection to the challenge and state the facts and arguments relied upon. He shall be given opportunity to be heard on the matter. Number 4, notwithstanding the rejection of the challenge by the challenge arbitrator, within the same period of 15 days, the parties may agree to the challenge and replace the challenge arbitrator. Number 5, if the challenge arbitrator does not accept the challenge or does not withdraw from his office, and the parties do not agree to the challenge, the arbitral tribunal shall decide the challenge within 30 days from receipt of the notice of the decision rejecting the challenge. Number 6, if the challenge before the arbitral tribunal is not successful or a party or tribunal shall decline to act within 30 days from the notice of the decision rejecting the challenge, the challenging parties may request the appointing authority to decide the challenge. Number 7, if the appointing authority shall fail to act on the challenge within 30 days from the receipt of this particular request, the requesting party may, with the notice to the parties, renew the request with the court. Number 8, until a decision is made by the challenge arbitrator, the parties, arbitral tribunal, or the appointing authority, the arbitration proceeding shall continue notwithstanding the challenge, and the challenged arbitrator shall continue to participate as arbitrator. Once the challenge is elevated to the court, the arbitration or the arbitration's proceeding shall be suspended until after the court shall have decided the incident. Number 9, the decision of the parties, the arbitral tribunal, the appointing authority, and the court to accept or reject a challenge shall be immediately executory, and it's not subject to appeal or motion for reconsideration. Number 10, the appointment of a substitute shall be made pursuant to the procedure applicable to the appointment of the arbitrator being replaced. As in the case of international commercial arbitration, if an arbitrator in a domestic arbitration becomes de jure or de facto, de jure or de facto means by law or by right, to perform or unable to perform his functions or fails to act without undue delay, his mandate terminates if he withdraws or the parties agree on the termination. If the controversy remains, any party may request the appointing authority to decide on the termination of the arbitrator, which decision shall be immediately executory and shall not be subject to motion for reconsideration or to an appeal. The default procedure in domestic arbitration is as follows. 1. The claimant in domestic arbitration is required to submit within the time agreed upon by the parties or determined by the arbitral tribunal his statement of claims, including the supporting facts, point or points at issue, and the relief suit. Second, in the same manner and period, the respondent shall state his defenses. Third, the parties may amend or supplement their claims or defenses as the case may be, unless the arbitral tribunal considers the amendment appropriate or dilatory. Number 4, in an ad hoc domestic arbitration, the procedure determined by the arbitrator with the agreement of the parties shall be followed. In an institutional arbitrator shall be followed which has been impliedly accepted by the parties on account of the designation of the institutional arbitral tribunal. So here are the procedures to follow in domestic arbitration. A. Pre-hearing conference. The parties in domestic arbitration are required to undergo a pre-hearing conference within 30 days from the appointment of the arbitrator or the constitution of an arbitral tribunal, during which they shall discuss the venue of the arbitration. The possibility of a compromise is not among those that the parties and the arbitral tribunal are supposed to discuss during the pre-hearing conference. No arbitrator shall act as mediator in any proceeding where he is acting as an arbitrator except where, under a settlement agreement, the parties agree to constitute the mediator as the arbitrator. Letter B. Threshold issues. Issues on the jurisdiction of the arbitral tribunal over the claims and counterclaims, or the arbitrability of the claims or counterclaims, shall be resolved by the arbitral tribunal as threshold issues if the parties so request, unless the issues are intertwined with the factual issues that they cannot be resolved ahead of the hearing on the merits. Letter C. Hearing dates and postponements. Arbitral tribunal shall, in consultation with the parties, fix the date and the time of hearings. The hearings shall not be postponed except with the conformity of the arbitrator and for good and sufficient cause. Letter D. Default of the party. If the claimant fails to communicate his statement of claims, the tribunal shall terminate the proceedings. If it is the respondent who fails to communicate his statement of defenses, the arbitral tribunal shall continue the proceedings without treating such failure in itself as an admission of the claimant's allegation. If any party fails to appear or produce evidence, he shall have them waive them. Letter E. Decision on the interlocutory. The arbitral tribunal may authorize its chairman to issue or release its decision on interlocutory matters. Letter F. Consolidation or concurrent hearing. They may agree to consolidate the arbitration proceedings with other arbitration proceedings or hold concurrent hearings. Letter G. Closure of hearing. No further motion, manifestation, or submission may be allowed except for post-hearing briefs and reply briefs unless the tribunal, motu proprio or upon the request of a party, allows the reopening of the hearing. Rules on taking evidence. The following rules on reception as well as the processes that the tribunal may employ in taking evidence. For testimonial evidence, witnesses shall be required to take an oath or affirmation to tell the truth, and the parties may also agree in writing to submit their dispute to arbitration other than by oral hearing. Documentary evidence. The tribunal may require the parties to submit or produce such other necessary documents. Or subpoena, the tribunal shall have the power to issue subpoena. The tribunal may appoint one or more experts to report to it on specific issues. They may require the parties to submit relevant information or grant access to such expert and may grant the parties opportunity to ask questions of the expert and present their own experts to testify on the points at issue. However, in domestic arbitration, upon the agreement of the parties, the finding of the expert engaged by the tribunal shall be uh, binding upon them and the tribunal. Letter E, the provisions of the IRR on domestic arbitration is specified some of other moods. The decision of the tribunal shall be made by the sole arbitrator or unless otherwise agreed upon by the parties. By the majority of the arbitrators in multi-arbitrator proceedings. However, questions of procedure may be decided by the chairman of the tribunal if authorized by the parties or by all members of the tribunal. The tribunal shall render its written award within 30 days after the closing of the hearing, submission of the parties' briefs. The award in domestic arbitration shall be in writing, signed by the arbitrator, and shall state the rendition and the place of arbitration. The award need not be acknowledged or sworn to unless required by the parties. The parties may require the tribunal to supply the omission within 30 days from receipt of the award. The proceedings will be terminated by the execution of an arbitral award on agreement terms, unless the respondent objects for the purpose of prosecuting his counterclaim or the tribunal recognizes a legitimate interest on his part in obtaining a final settlement of the dispute. The parties to a domestic arbitration may seek from the arbitrator or tribunal interim measures including preliminary injunction, appointment of receiver, detention of property, and preservation and inspection. Either party may also secure assistance from the courts for the implementation of interim measures. Multi-party arbitration. In a multi-party domestic arbitration, the tribunal is permitted to implement procedural modification as it shall deem to appropriate to address the complexities of the multi-party arbitration, which includes the fees and costs, okay, of these particular proceedings. General rule is that the fees of the arbitrator in domestic arbitration shall be determined by the agreement of the parties in writing prior to the arbitration. In default, the arbitrators or the arbitrator's fee shall be determined in accordance with the applicable rules of the regular arbitration institution. Under Article 5, Section 32, Paragraph D of the IRR emphatically states that no motion for reconsideration or correction and interpretation of the award or additional award shall be filed with the tribunal. This is premised upon the principle that when the tribunal renders its final award, it loses jurisdiction over the dispute and the parties to the arbitration. However, under Section 17 of Republic Act 876 specifically allows the continuation of the arbitral proceedings motu proprio by the arbitrators or upon motion of party upon good cause shown. The IRR provided for the amendment or modification of the award in the following instances as exceptions to the general rule. 1. If provided, the tribunal may cause the amendment. Number 2. If the tribunal failed to resolve an issue, parties may ask for the resolution. Number 3. If the tribunal made reservation in the final award, it may supplement the award by such quantification, determination, or apportionment. Number 4, a party may ask the tribunal for the correction of the award within 30 days from the receipt of the award and with notice to the other party. Number 5, within the same period, the parties may agree to request the tribunal to give an interpretation on the specific point or part of the award. Number 6, within 30 days from the date of the award, the tribunal may motu proprio or correct any typographical error. Number 7, within 30 days from the receipt of the award, a party with notice to the others may request the tribunal to make an additional award as to claims presented in the arbitral proceedings but omitted in the award. If justified, the tribunal shall make the additional award within 60 days from the receipt of the request, unless the parties have granted upon any period of time. So the parties may ask for correction, interpretation, or the rendition of an additional award within 30 days from the receipt of the award. The foregoing grounds for amendment or modification of arbitral award by the tribunal should be distinguished from the grounds for the amendment or modification of an arbitral award by the court. A court may amend or modify a domestic arbitral award in the following instances. 1. Where there is an evident miscalculation of figures or an evident mistake in the description of any person, thing, or property referred to in the award. Second, where the arbitrators have awarded upon a matter not submitted to them, not affecting the merits of the decision upon the matter submitted. 3. Where the award is imperfect in a matter of form not affecting the merits of the controversy, and if it has been a commissioner's report, the defect could have been amended or disregarded by the court. If the award upon a matter not submitted for arbitration, or if the imperfect form of the award affects the merits of the decision or controversy, the award should be vacated instead of merely being amended or modified by the court. So the notice of a motion to vacate, modify, or correct an award must be served upon the adverse party within 30 days after the award is filed or delivered. The judgment of the regional trial court rendered in a motion to confirm, modify, correct, or vacate an award shall have the same force and effect as judgment in an action, and may be enforced as if it had been rendered in the court in which is entered. Setting aside an arbitral award, a domestic award may be set aside through courts only on the following grounds. 1. The arbitral award was procured by corruption, fraud, or other undue means. 2. There was evident partiality or corruption in the tribunal or any of its members. 3. The tribunal was guilty of misconduct of any form of misbehavior that has materially prejudiced the rights of any party. 4. One or more of the arbitrators was disqualified to act as such and willfully refrain from disclosing such disqualification. And number 5, the arbitral tribunal exceeded its powers or so imperfectly executed them such that a complete, final, and definite award upon the subject matter submitted to it was not made. The petitioner furnishes proof that there was a defect in the arbitration agreement because a party was under some incapacity or agreement is not valid under applicable laws. B. Violation of due process because the petitioner was not given proper notice of the appointment of an arbitrator or the proceeding or unable to present his case. Letter C. Lack or excess of jurisdiction on the part of the tribunal because the award deals with a dispute not contemplated by or not falling within the terms of the submission or arbitration. So it is subject to the application of doctrine of severability or separability. Letter D. Violation of the arbitration agreement because the composition of the arbitral tribunal or the arbitral process was not in accordance with the agreement of the parties unless such agreement was in conflict with the provision of the Alternative Dispute Resolution Act, from which the parties cannot derogate or following such agreement was not in accordance with the Alternative Dispute Resolution Act, or the court finds that the subject of the dispute is not capable of settlement under the laws of the Republic, and the award is in conflict with the public policy of the Republic. The court before which the petition for setting aside the domestic arbitral award is filed has the prerogative and option to suspend the court proceedings in the following instances. 1. The court may suspend the setting aside proceedings to give the tribunal an opportunity to resume the arbitral award proceedings or take such action which will eliminate the grounds for setting aside an award. Second, the petitioner or the oppositor may petition the court to remit the case to the same tribunal for the purpose of making new or revised final and definite award, or to direct a new hearing before the same or new tribunal. Or number three, if the ground for vacating an arbitral award does not affect the merits of the case and may be cured or remedied, the adverse party may oppose the petition and instead request the court to suspend the vacation or setting aside proceedings to give the arbitral tribunal an opportunity to cure or remedy the award or resume the arbitration proceedings or take such action as will eliminate the grounds for vacation or setting aside. In the foregoing instances, opportunity is being given to the tribunal to cure any defect in its proceedings and awards. The recognition of a domestic arbitral award is made by filing a motion for confirmation and securing an entry of judgment from the court. An award in domestic arbitration is rendered by a Philippine Arbitral Tribunal applying the uh, Republic law. All that is required in order to enforce a domestic award is to have it confirmed through a motion filed in court. Similar to international commercial arbitration, proceedings for recognition and enforcement, vacation or setting aside an award, and any application for arbitration assistance, except appeal, shall be deemed as special proceedings. We also have other forms of alternative dispute resolution. Neutral evaluation is an alternative dispute resolution process wherein the parties and their lawyers are brought together to present summaries of their cases and to receive a non-binding assessment by an experienced neutral person with the expertise in the subject matter or substance of the dispute. Early neutral evaluation is availed of early in the pretrial phase. The agreement of the parties shall govern the conduct of neutral or early neutral evaluation. In default, the provisions of the implementing rules and regulation on neutral or early neutral evaluation shall apply. Essentially, this kind of alternative dispute resolution is akin to mediation and hence, in the absence of an agreement between the parties or specific provisions of the law or rules applicable to them, the rules on mediation shall apply as suppletory. However, the parties may, in the exercise of their right to party autonomy and self-determination, empower the neutral third person to render a binding assessment, in which case this too becomes akin to domestic arbitration. In the rules on arbitration shall apply suppletory. If the parties cannot or fail to agree on the qualification of the neutral third person, the manner of his selection of the appointing authority, or if the parties are unable to make the selection despite their agreement on the foregoing, either party may request the default appoint to authority to make the appointment. In the neutral evaluation, the parties are required to submit and exchange position papers containing the issues and statements of the relevant facts and append their supporting documents and affidavits of witnesses. In order to maintain impartiality of the neutral third person, there shall be no ex parte communication between him and any party to the dispute. Confidentiality of the proceedings, communications, and assessment shall also be maintained. The neutral third person shall issue a written evaluation or assessment within 30 days from the conclusion of the evaluation. Mini trial is a structured dispute resolution in which the merits of the case are argued before a panel composed of senior decision makers with or without the presence of a neutral third person before which the parties seek a negotiated settlement. The agreement of the parties shall govern the conduct of the proceedings, in the absence of which the provisions of the implementing rules and regulations on mini trial shall be applicable. A mini trial may be conducted either as a separate dispute resolution process or as a continuation of mediation or neutral or early neutral evaluation or any alternative dispute resolution process. In either case, the presence of a neutral third person can be dispensed with, otherwise shall preside over the mini trial. The parties shall appoint the panel of senior executive or decision makers. They may choose one or more for each party, provided that the parties shall appoint an equal number of senior executives or decision makers. The parties shall submit a brief summary of the dispute, identifying the specific factual or legal issues, after which they shall appear before the mini trial panel or the members, before whom their lawyers shall present their respective cases, starting with the claimant. Thereafter, the lawyers or representatives may offer rebuttal or surrebuttal arguments. The presentation in chief shall be made without interruption for 1 hour, and the rebuttal and surrebuttal shall be for 30 minutes unless a different period is agreed upon by the parties. Parties may ask clarificatory questions after each presentation. After the mini trial, the panel members, with the assistance of neutral third party, shall negotiate a settled dispute. Mediation arbitration is a kind of alternative dispute resolution which includes two-step dispute resolution process involving mediation, then followed by the arbitration. The proceedings shall be governed by the agreement of the parties. In the absence of the agreement and in view of its dual nature, its proceedings shall be governed by the rules on mediation first and thereafter. By the rules on domestic arbitration, as I discussed a while ago, as a rule, no arbitrator shall act as mediator and no mediator shall act as arbitrator at the same time in any proceeding. The mediator appointed is precluded from acting as arbitrator of the same dispute unless the parties have agreed in writing. Take note, there must be a written agreement. A mediator is precluded from discussing with the parties the merits of dispute. During the dispute stage, the mediator is authorized in writing to act as arbitrator, shall make an appropriate disclosure as if the arbitration proceeding had just commenced. Likewise, he shall take the appropriate oath or affirmation as an arbitrator. The combination and innominate forms of alternative dispute resolution. The parties are allowed to avail any combination of alternative dispute resolution forms. The parties may even come up with their own forms or methods, which innominate may be allowed by law as long as they satisfy the requisites of alternative dispute resolution and they comply with essential requisites of a valid contract and are not contrary to the law, morals, public policy, public order, and good customs. As in the case of the nominate alternative dispute resolution forms, the combinations and innominate alternative dispute resolution forms are governed principally by the agreement of the parties. In the absence of agreement, the rules and procedures for mediation are suppletory applicable of the combination or innominate alternative dispute resolution form is similar to mediation. Otherwise, apply the rules of arbitration. Thank you so much for watching and listening this lecture. I hope so you're ready with your activities.